Hello everyone, welcome to Courts Today by Live Law, your one-step destination for the latest and fastest legal updates. I'm your host Urvashi Chauhan, bringing you day-to-day happenings, landmark judgments, crucial rulings and expert insights into the world of law. Let us start. We start with the headlines and a brief overview of the top stories. We will then dive into the full details and in-depth coverage of each update. The West Bengal government has passed an anti-rape bill in the State Assembly today, which proposes time-bound trial and death penalty for those guilty of rape. The Supreme Court has sought a report from the Madras High Court with respect to a judgment after the CBI claimed that the detailed order was uploaded after the judge's retirement from the High Court. The Supreme Court has directed that online presence of only those advocates who are either present or assisting in the court will be marked. The Apex Court has asked the Union government not to object to deportation of a Myanmar national detained since 2012, as Canada is willing to accept him. Actor Kangana Ranaut's film Emergency will not be releasing this Friday. In a PIL against its release before the MP High Court, the CBFC informed that the film's certification application is still under review. The Kerala High Court has quashed a case against a rape accused after noting that the FIR was filed 16 years after the alleged incident without a reasonable explanation. The Karnataka High Court has quashed NDPS proceedings against a 68-year-old owner of a property where narcotic drugs were found due to lack of evidence of his knowledge. Starting with an important update from the state of West Bengal. In the wake of great unrest due to the brutal rape and murder of a resident doctor at the government-run RG Medical College and Hospital in Kolkata, which led to widespread protests all across the country, the Mamata Banerjee-led government has passed an anti-rape amendment bill. Titled Aparajita Woman and Child West Bengal Criminal Laws Amendment Bill 2024, it proposes to create a safer environment for women and children in the state and seeks to enhance the already prevalent penalties for rape. According to the newly tabled bill, it seeks to amend various sections of the Bharatiya Nyaya Sanhita 2023, which pertain to punishment for rape and murder, gang rape, repeat offenders, disclosure of victim identity, and even causing hurt by use of acid, etc. It also proposes to remove the concessions under the BNS for child offenders who are found guilty of the offence of rape. The bill is set to come into effect from 5th September 2024. The Supreme Court has today directed the Registrar General of Madras High Court to submit a report following CBI's claim that the High Court had passed a single-line order in a case and that the detailed order was not made available till the judge demitted office. The case centers on an IRS officer accused of accumulating assets worth over 3.2 crores, allegedly disproportionate to his known income between the years 2002 and 2014. The officer was serving as Additional Commissioner for Income Tax when the FIR was registered. The CBI claimed that these assets, including those in his wife's name, were not satisfactorily explained. But the High Court Judge, Justice T. Mathivanan, had quashed the FIR against the officer, suggesting that it was driven by personal vendetta. The CBI contested this order and has approached the Supreme Court. According to CBI, the single judge passed a one-line order in court on 15th May 2017, and on the same day, it applied for a certified copy of the order. The counsel appearing for CBI submitted that the registry orally informed the CBI that detailed order had not been received from the judge's office. The concerned judge retired on 26th May that year. The CBI was provided with a certified copy of the impugned order only on 26th July. The CBI's lawyer also informed the court about a letter from their special public prosecutor to the joint director stating that 9 cases handled by the judge were ordered to be reheard. Although the letter did not mention the number of this specific case, the CBI argued that it was included among those 9 cases for a fresh hearing. A bench of Justices Abhay S. Oak and Augustine George Massey directed the Registrar General of the Madras High Court to provide details on when the detailed judgment was received and uploaded by the registry. Additionally, the bench has asked whether the Chief Justice issued any administrative directive for a fresh hearing of the 9 cases heard by the judge and whether the case currently under appeal was included in those cases or not. The report of the High Court Registrar is to be submitted by the end of this month. Let me also tell you here that this is not the first time when the Supreme Court has dealt with such an issue. Recently, it quashed a judgment by the same judge of the Madras High Court on the ground that the judge released detailed reasons for a judgment nearly 5 months after retirement. It observed that a judge retaining the case file, issuing a detailed judgment post-retirement was a gross impropriety. In the next update, the bench of Justices J.K. Maheshwari and Rajesh Bindal has criticized the practice of marking the presence of an advocate who is neither physically nor virtually present during the proceedings. The bench was hearing a case where an advocate on record appearing for a party was not present in the court either virtually or physically. Instead, a request was made by an advocate to accommodate him since the AOR representing the party was out of town. Subsequently, on the next date of hearing also, the advocate on record was not present in the court both physically and virtually, but his name was submitted through an online portal to mark his presence in the proceedings. The court objected to this and termed it as an unethical practice. It reviewed a circular from the Supreme Court's registry dated December 2022. This circular allowed advocates on record to mark the presence of advocates appearing in court via an online portal. The court noted that the instruction required the advocates on record to report only those advocates who were physically or online present in the case and not those who were neither present in person nor online. Thus, the court directed that only the presence of those advocates would be marked who were either present in the case or assisting in the court. In the strict sense, the bench also said that presence of those advocates would not be marked who were, though not present in the court, but associated with the advocate's office. The court has requested the Supreme Court Bar Association and Supreme Court Advocates on Record Association to furnish online presence only of those advocates who are present in the court. It has also requested presidents of various bar associations of the Supreme Court to look into the issue and notify the members for taking corrective steps. In another development, the Supreme Court has called for the Union government's response regarding a detained Myanmar national seeking refuge in Canada. The petitioner, who has been held in Manipur detention center since 2012, claims that Canada is ready to accept him as a refugee. However, the process is stalled due to his detention. The court, led by Justices B.R. Gavai and K.V. Vishwanathan, has directed the Additional Solicitor General Aishwarya Bhati to obtain instructions from the Ministry of Home Affairs. Justice Gavai emphasized that given the unique circumstances, there should be no objection to the petitioner being sent to Canada if the country is willing to accept him. The court noted that the Canadian High Commission has already approved the petitioner's resettlement. During the hearing, let me tell you, it was revealed that the union received confirmation of the petitioner's identity from Myanmar in May 2022. However, the confirmation expired after a month and efforts to renew it are still pending. The petitioner's counsel argued that since the Canadian embassy is prepared to process his refugee status, he should be transferred from Manipur to a Delhi detention center to complete the necessary formalities. The ASG cited concerns about deporting an illegal immigrant to a third country and highlighted issues with managing numerous similar cases. The court has today adjourned the hearing, giving the union government time to verify the facts and obtain further instructions. And now coming to an update on the PIL filed before the Madhya Pradesh High Court against release of Kangana Ranaut starrer movie Emergency. This film is set during the 1975 emergency about former Prime Minister Indira Gandhi. The PIL petitioners Jabalpur Singh Sangat and Guru Singh Sabha Indore have moved the court, claiming that the film contains scenes that violate the fundamental rights of the Sikh community. According to them, the film's depiction of specific historical events, particularly the use of the term Khalistan, could have negative consequences for the Sikh community. Yesterday, the bench issued notice to Central Government and Central Board of Film Certification, that is CBFC. Today, the board submitted before the bench of Acting Chief Justice Sanjeev Sachdeva and Justice Vinay Saraf that the application for certification of the movie was still pending consideration and no certificate had been issued. In view of this, the court, directing the board to consider the representations moved before it in respect of the film's trailer, disposed of the PIL plea. The court also refused to pass any other order as it emphasized that the board was the competent authority to grant certificates to the film. In another update, the Kerala High Court has quashed criminal proceedings against a rape accused, citing 16-year delay in filing the rape case as a critical factor. The petitioner here was accused of raping the complainant, a married lady, in the year 2001. However, the FIR was only filed in 2017. The court found the 16-year delay in lodging the complaint was detrimental to the prosecution's case, making the allegations doubtful. Justice A. Bahaduruddin also observed that the complainant continued her relationship with the accused after the alleged incident. This suggested that the sexual relationship was consensual. The woman had also reportedly lent the accused 20 lakh rupees during their relationship, which was highlighted as further evidence of consent. The court also noted that the woman had no further grievances and that the matter had been resolved between the parties. The court emphasized that significant delay in reporting the case without a satisfactory explanation casts doubt on the authenticity of the allegations. It thus quashed the criminal proceedings against the petitioner. And lastly, the Karnataka High Court has quashed criminal proceedings against R. Gopal Reddy, a property owner accused under the Narcotic Drugs and Psychotropic Substances Act. The court emphasizing that an owner can only be held liable if they knowingly permit the premises to be used for illegal activities. In this case, let me tell you, an event management company rented Reddy's property for a birthday celebration. A subsequent raid on the premises led to seizure of narcotic drugs and psychotropic substances, after which he was implicated in this case. Reddy, a 68-year-old residing elsewhere, argued that he had no knowledge of the activities occurring on the rented property, which was managed by a property manager. The court noted that even the officials who conducted the raid did not indicate that Reddy was aware of the illegal activities. No other evidence suggested his involvement. The prosecution had contended that the issue of Reddy's knowledge should be determined at trial, but the court disagreed, stating that it would be unjust to subject him to trial without clear evidence of his knowledge. Justice M. Nagprasanna highlighted that Section 25 of the NDPS Act imposes vicarious liability on property owners who knowingly allow their premises to be used for criminal activities. However, in this case, the prosecution failed to provide prima facie evidence of Reddy's knowledge. The court therefore quashed the proceedings against him. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.